Welcome back to One Stop Law. On Monday, 7th November 2022, the Supreme Court of India, by a 3:2 split verdict, has upheld the validity of the 103rd Constitutional Amendment carried out to provide legal sanction to government's decision to carve out 10% reservation for economically weaker sections, that is EWS, for unreserved classes for admission in educational institutions and government jobs, and has held that the 50% cap on quota was not inviolable, and affirmative action on economic basis may go a long way in eradicating caste-based reservation in India. This case came when a certain number of petitioners, which included an NGO named Janhit Abhiyan Youth for Equality and others, had challenged the 103rd Constitutional Amendment on the ground that it is unconstitutional to provide reservation in India solely on the ground of economic classification. The 103rd Constitutional Amendment Act was passed in January 2009 to insert Articles 15 Clause 6 and 16 Clause 6 in the Indian Constitution to provide for reservation in public and private educational institutions in India and in public government job employments over and above the existing near about 50% reservation for the economically weaker sections, which includes the SCs, STs and OBCs, etc. Here the petitioners argued that the 103rd Constitutional Amendment violates the basic structure of the Indian Constitution as it breaches the 50% ceiling reservation as decided in the Indira Savani case. They also argued that non-inclusion of SC, ST, OBC in the 10% reservation for economically weaker sections is arbitrary, excessive and violative of the constitutional right to equality. The Supreme Court had to decide whether the 103rd Constitutional Amendment breached the basic structure of the Indian Constitution primarily on three grounds. Number one, does it give the state the right to give reservation solely on economic criteria? Number two, does it breach the basic structure on the ground that even private unaided educational institutions are also made bound to give 10% reservations? And third, and the most important question, that does the 103rd Constitutional Amendment Act violate the basic structure of the Indian Constitution on the ground of equality, because SC, ST, OBC and SEBC all are excluded from the 10% reservation of EWS. The hearing to the case was concluded on 27 September 2022 by a 5-judge constitutional bench of the Supreme Court, and yesterday on 7th November, the Supreme Court gave a split verdict with a majority ratio of 3:2. A 5-judge bench including Chief Justice E.W. Lalit, Justices Dinesh Maheshwari, Justice Ravindra Bhat, Justice Bela M. Trivedi and Justice J.B. Pardiwala approved the amendments by majority ratio of 3:2, which would push the total reservation to 59.5% in central institutions in India. All judges agreed that reservation on the basis of economic status was justified in the light of constitutional amendment, while approving the quantum of quota going beyond 50% ceiling that the apex court had laid down in Indira Savani case. However, in their dissenting verdict, Chief Justice E.W. Lalit and Justice Bhat struck down the amendment holding the exclusion of SCs, STs and OBCs from the purview of economic backwardness to be discriminatory and arbitrary. If we look at the majority opinion of the verdict, we see Justice Dinesh Maheshwari saying, and I quote him, "Economically weaker section amendment does not violate the basic structure as it is based in economic criteria. State forming special provision for EWS quota does not violate the basic structure." He also said reservation is an instrument of affirmative action so as to ensure all-inclusive march towards goals of egalitarian society. It is a means of inclusion of any class or section so disadvantaged. Reservation on economic basis does not violate the basic structure of the Indian Constitution. He also said the breach of 50% ceiling laid down by the Supreme Court in Indira Savani case for reservations applicable only for reservation with respect to socially backward classes under Article 16 Clause 4 and Article 16 Clause 5 of the Indian Constitution. Agreeing to Justice Dinesh Maheshwari, Justice Bela Trivedi said, the amendment enabling state to make special provision for those other than the scheduled caste, scheduled tribes should be treated as affirmative action by the Parliament. Forming a part of the majority opinion, Justice J.B. Pardiwala also upheld the 103rd EWS reservation, but he said that reservation in India should not be indefinite. I quote him, reservation should not continue for indefinite time so that it becomes a vested interest. Of the two dissenting judges, one was Justice Ravindra Bhat, who said that the amendment is deluding us to believe that those getting social and backward class benefit is somehow better placed. He even referred to the Sinha Commission report, which stated that 38% of total SC population and 48% of total ST population in India lives below the poverty line. So he said that while reservation on economic basis is permissible, yet excluding SCs, STs and OBCs from economically weaker section definition cannot be permitted, and it amounts to discrimination against them. Chief Justice of India, Justice E.W. Lalit, on his last working day, concurred with Justice Ravindra Bhat's view in the dissenting opinion to this judgment, as he also held that the EWS reservation is not constitutionally right. He said, and I quote him, our constitution does not permit exclusion, and this amendment undermines the fabric of social justice and thereby the basic structure. He further said, this court has held that Article 16 Clause 1 and 4 are facets of the same equality principle. The characterization of excluding the poor of SEBCs is not correct. What is described as benefits cannot be understood as a free pass. It is a compensatory mechanism to repair it. The exclusion is based on social origin, which destroys the equality code. So, with a split verdict, the 10% economically weaker section quota has been upheld by the Supreme Court in a 3:2 ratio. But what is more interesting to note here are the written observation of the judges in this verdict, which has a capacity to ignite political debate on reservation in future, because it is very interesting to note that the two Supreme Court judges who have upheld this EWS reservation have suggested that reservation was introduced in India as a temporary measure, and so it cannot be allowed to go on and become a perpetual practice. Rather, they suggested that reservation should have some time limit. Justice Bela M. Trivedi, who forms a part of the majority opinion, has said that it cannot be said that age-old caste system in India led to introduction of reservations and so that SC, ST get level playing field. At end of 75 years, we need to take a relook at reservations in general spirit of transformative constitutionalism. She referred to Article 334 of the Indian Constitution, which envisaged a time limit for reservation of scheduled castes and scheduled tribes in the Parliament and state legislatures, which is being extended from time to time. She said the representation for Anglo-Indian community in the Parliament and the state legislative assemblies has already been done away with after the 104th Constitution Amendment. So she further stressed that if similar timeline is provided for the reservations provided for SCs, STs and OBC categories under Article 15 and 16 of the Constitution, it will lead to an egalitarian, classless and casteless society. So theoretically what she is saying is that such reservation for economically weaker sections is only reaffirming the existing lines of caste and class system in our society, which is still existing. Another judge who also formed a part of the majority opinion, Justice J.B. Pardiwala, also agreed to Justice Bela Trivedi and said, reservation in India should not continue for indefinite time so that it becomes a vested interest. He also said that reservation is not an end but a means to secure social and economic justice. He further pointed out, and I quote him, the long-standing development and spread of education have resulted in integrating the gap between the classes to a considerable extent. The real solution lies in eliminating the causes that have led to the social and educational backwardness of the weaker sections. This exercise of eliminating the causes started immediately after the independence, that is almost 7 decades back, and still continues. The ones who have moved ahead should be removed from backward classes so that ones in need can be helped. The ways to determine the backward classes need a relook so that ways are relevant in today's time. So basically what Justice Pardiwala and Justice Trivedi have said in their written observations, they have basically reiterated what Dr. B.R. Ambedkar had suggested while introducing reservation in the Constitution, that it is only for 10 years to introduce social harmony. But today it has, till remained in our Constitution for over 7 decades. So the question is, how much more? Shall it continue for another 7 decades or even more? Because the ground reality is that Indian politics have failed to provide social equality. Caste discrimination and oppression is still very much a part of our naked reality in India. So basically, in conclusion, we can say that reservation is nothing but a band-aid, and it is unfortunate that the caste divisions and oppressions run deep inside our society till date. That's all for this video. Till I see you in some other lecture. Thank you all.